Your Maynard Surco?
She's mad.
Have you talked to this lady, your attorney?
This is our initial appearance, Judge. This is my first contact with him. I'm getting good contact information from him today, providing my information so that we can figure out what to do going forward.
This one is another one that was set 5 weeks ago for
Just like I told you about, I had a disease.
resetting.
Judge, it's an initial experience. So
Yeah.
I document, I have not had contact with this man.
The initial, it was, the initial docket was he was here at 9/24 to 1/5. But when are you gonna talk to her? She's not gonna track you down. You gotta talk to this lady. Unless you want to represent yourself, you're looking at a 3rd-degree felony of evading arrest or detention, which carries with it up to 10 years in prison, which is serious. If it would be for me. Maybe it's not for you, but I think it ought to be serious. I would be contacting her all the time to make sure that I'm getting that.
I haven't even.
Hold on, only one of us can speak at a time.
I'm sorry.
This lady takes everything down, and when 2 people speak over each other, the court reporter can't do her job. And the Court of Criminal Appeals says if somebody interferes with her job, then they get held in contempt of court. And we're not gonna, let's be polite. You're gonna get a chance to speak. Do you know how to reach her?
No, he does not, Judge. It's the first time that we've met each other.
Communicate
Yes, sir.
and move forward. But this one is another one that you need to be very careful. I don't see a prior conviction. Have you ever been convicted of anything before?
No,
Well, this could be fixable,
so
you know,
It's my
but she's
first-
your lifeline and
been going through a lot.
welcome to planet Earth. Everybody's got everybody's problems. Sometimes it's more difficult times than other times, but it always, that's the way for everybody. Bad times, good, and dealing with the bad times. If it's a difficult situation, she is great person to be your lawyer. She'll guide you through this. And, but if you make, we're all held accountable when we all make mistakes. When we make a mistake, fix it responsibly, move on and don't make the mistake again. And that's the test. Not because you made a mistake. The test is how do you deal with your mistake? Responsibly or irresponsibly? It's your decision, like all of us. So get this fixed and get some of these problems you have with your life fixed and smoothed out, and then move on and be the best you can be. That's because do you have any prior convictions? No? Well, don't start now. Fix this. What do you want to do with your life?
Well,
I mean, what do you want to do?
Good
What do you want to
job.
be? You know,
I want to get in plans.
sir?
I want to get in plans. And
In the plants, like.
Oh, the refineries?
Kivo.
Okay. Do you have a skill or a training?
I want to be welding.
What about it? Have you gone to welding school yet?
No,
Oh,
sir.
okay. That's a great job. Well, and
But I need to, experience the first. So,
associate's degree, 2 years. You can get something like that. All right. Well, anyway, talk to her. I'm going to give you 3 weeks.
Can we do 4, Judge? I'm not sure if the other one was meeting.
All right. We'll set on it
Office.
for 4.
Thank you.
Get a resetting.
thank you.
With Mr. Cobb, your attorney and the state's attorney. Does the defendant waive a reading of this indictment? Can we proceed in summary?
He does.
All right. First of all, this alleges the 3rd-degree felony of misapplication of trust funds. Apparently, a deal has been worked out where the defendant.
It's a lesser included, it's class A.
How is it a lesser included? So we don't have.
Because you take the intent to defraud out, and it's a class A misdemeanor.
Here's the penalties and the statute we look at here. It's property code.
It was indicted out of section 162.031.
It's on the other side of the page. Yes, sir.
of,
It's got the statute and then it's a class A misdemeanor except for if
which
it's
code is this?
property code.
The property code.
Yes, sir. That's why I printed off a copy for you because I know that I'm just keep my line out.
Start with D.
All right, we're proceeding, it looks like on, under the statute, which statutes outside the penal code are always seem to be worded a little more hard to understand, complex than what's in the penal code. But here, under section 162 of the Texas Property Code, there is a provision concerning punishment and illegality, criminal illegality for what is referred to as misapplication of trust funds. And a person who intentionally or knowingly or with intent to defraud somehow misapplies trust funds, then that can be an offense as high as a third-degree felony. The statute goes on to provide under section 162.032 under the penalty section of part B, a person who misapplies trust funds amounting, under part A of the penalties, a trustee who misapplies trust funds amounting to $500 or more in violation of this chapter commits a class A misdemeanor, which is, I think, the portion that the parties have decided to proceed on. Is that your understanding of the plan? It's a class A misdemeanor, which carries with it up to 1 year in the county jail and or a $4,000 fine, or both. Is that your understanding of the punishment range? So of a class A misdemeanor?
Yes, sir.
Agreements have further been reached, you'd be pleading guilty, sentenced to 1 year in the county jail. That would be suspended. You would be placed on probation for up to 2 years. Restitution is owed in the amount of $3,000. How is that going to be paid and how quickly?
It took.
Do you have a plan? How much can you pay a month?
I maybe 500. I use, I'm pretty sure I saved it, way it always goes, 60 months. 500 is much, definitely out of business.
All right, how do you plead to this lesser included class A misdemeanor, which is provided under section 162.032 subpart A under the penalty section, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? And because you are guilty?
Voluntarily, I can hear you, so.
Yeah, that means you're doing it on your own free will. Nobody put a gun to your head. Correct? Or something like that.
I'm just deaf.
You understand what free will means? Voluntarily.
Yes, sir.
Show you here what's marked as State's Exhibit 1. Did you sign that document?
Yes, sure.
No. Understand it, discuss it with your attorney, or the contents are incorrect?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. The states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. You, Brenda. You are guilty of the crime charged in any lesser included offenses, such as this one. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all through so help you God. States Exhibit 1, part of the record without objection for all purposes. Pre-sentence report is waived. Yes,
Yes.
I'm going to follow this agreement. And again, how do you plead to this lesser included? Guilty or not guilty?
Guilty.
And you are pleading guilty voluntarily and because you are guilty.
Yes, sir.
I'm going to find you are pleading guilty voluntarily. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this Class A misdemeanor of misapplication of trust funds under Section 162 of the Texas Property Code, Subpart A. I am following this agreement. You were hereby sentenced to confinement in the county jail for 1 year for this Class A misdemeanor. I am going to suspend that confinement, place you on regular probation for 2 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. You, most importantly, must pay back restitution to stand by. The victim is not named here in the indictment. Who is the victim? Who is the victim? Do we know?
Second judge.
Okay.
Yeah, it's going to be the estate of
Mr. Coon, Richard Coon.
Richard Monroe Coon, COON. Yes, full name.
Okay. Richard Kuhn
Yes, sir.
is the victim in
Yes, sir.
this case. He's passed.
He's deceased. Yes, Your Honor.
His estate is going to be the beneficiary
Yes, sir.
of the
The remaining restitution. Yes, sir.
restitution in the amount of $3,000. The defendant has stated the defendant has stated he can pay $500 per month, and that will be ordered.
Yes.
There will be other terms and conditions of probation that the probation officer will go over with you. If you fail, your probation could be revoked. And then you've already been found guilty here. So just you're staying out of jail due to proper behavior and following the rules of probation. You could be sentenced up to 1 year in the county jail. So you don't want that. And pay these people back, the estate back. That's the right thing to do. Do you understand what has happened today, sir?
Yes, sir.
All right, please see the probation officer. Thank you. All right, we now call 21-38438. We recall this case that we are in trial for the state of Texas versus Ricky James Johnson. The defendant was indicted for the first-degree felony of murder. What are our plans today here, gentlemen?
Going to be a plea to the murder for 40 years and dismiss the aggravated assault.
Does the defendant waive a formal reading of this indictment and arraignment, Mr. Matuska, on his behalf? Can we
Yes, sir.
proceed in summary? In summary, Mr. Johnson, this indictment alleges that on or about September 12th, 2021, in Jefferson County, Texas, you committed the first-degree felony of murder by causing the death of Corey Dante Green Jr., and you used a deadly weapon, namely a fire. Do you understand what you have been charged with here, sir?
Yes, sir.
If convicted of this first-degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here?
Yes, sir.
An agreement has been reached here during this trial where you would be waiving a further jury trial, pleading guilty and sentenced to 40 years confinement in prison. And cause number 21-38439, an aggravated assault indictment that is also filed against you. That case will be dismissed. Is this your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Either cases. How do you plead to this indictment charging you with the first degree felony of murder, guilty or not guilty?
Plead guilty.
Sir,
Guilty.
are you pleading guilty voluntarily and because you are guilty of what this alleges?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Discuss it with your attorney, or the contents all true and correct here? State's Exhibit 1 is tendered into evidence
No objection.
and without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God. True?
True.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
If nothing further, I'm going to follow this agreement that's been reached by the parties. And I'm going to find as follows: that you, Ricky James Johnson, you are pleading guilty to this first degree felony of murder voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this first degree felony of murder. I now find you guilty beyond a reasonable doubt of this offense. And I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. You will be given credit for all time you have served in accordance with this case. Also, the judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offense. Do you understand what has happened today, sir?
Yes, sir.
Do you understand, sir? Okay. Anything else to add on this agreement and hearing from the defense?
No, Your Honor.
God bless you. And from the state?
No, Your Honor.
Okay. I believe there's going to be some allocution.
Yes, sir. There is an allocation.
Oh, tell me when you're ready, and you may be seated, sir.
It's a mother and daughter, and they live together, and it's
Two cases are now called. Cause numbers 25 CR 398 and 399, the state of Texas versus Cullen Rayford Cannon. You were Mr. Cannon. With Mr. Turk, your attorney, and the state's attorney. You were charged with the second degree felonies in each case. We're only going on paragraph 1.
that's correct, Your Honor.
And of aggravated assault with a deadly weapon. Does the defendant waive formal readings of the indictments and the arraignments here? Can we proceed in summary?
We may judge.
In summary, these indictments allege similarly that on or about February 26th, 2025, in Jefferson County, Texas, you committed the second degree felonies of aggravated assault with a deadly weapon by driving your vehicle that you were operating and apparently colliding with another vehicle occupied by the victims in each of these cases.
Yeah.
And
that
that in the manner of the use and intended use of the vehicle was capable of causing serious bodily injury or death, which means that's the definition of a deadly weapon under the state of Texas. And if convicted, this is a second degree felony, which means you were facing no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed on each case. Do you understand what you were facing, sir?
Yes, sir, I do.
Agreements have been reached on each of these cases similarly, right? That you would be placed on deferred or unadjudicated probation for up to 10 years in prison, for up to 10 years in length on the deferred or unadjudicated probation. I have probation or restitution is 15,000 to one victim. Is there restitution to the other?
Yes, 15 to the other.
$15,000 for each victim in each of these cases, totaling $30,000 in restitution.
Yes, sir.
Yes, Your Honor.
Is that your understanding of the agreement for each of these cases?
Yes, Your Honor.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, I do.
How do you plead in each of these cases, or guilty or not guilty?
I plead guilty.
Are you pleading guilty in each case voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. In each case, did you sign those documents? Did you understand them? Discuss them with your attorney? They're the same in each case? And are the contents all true and correct that you signed under oath?
Yes, sir, I signed it.
State's Exhibit 1 is tendered into evidence in each case without objection admitted. Each of these states similarly that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You were guilty of the crimes charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in each case. All of these are true, so help you God, it states.
Yes, sir.
States Exhibit 1 in each case are made part of the record in each case. Pre-sentence report is waiting.
Yes, Judge.
Court is going to follow these agreements and find, sir, in each of these cases, you are pleading guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt in each case. But I'm not going to do that. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation, which are for 10 years in length. You do well, it can be shortened to 1/3. Restitution is to be ordered in each of these cases to the respective victims in the amount of $15,000. There will be other terms and conditions of probation, which are normal and customary for these type of offenses. Please follow these terms and conditions of probation. If you fail, your probations could be revoked. You could then be found guilty and sentenced up to the full range of punishment, which means you're looking at up to 20 years in prison. Also, aside on this, a deadly weapon, an affirmative finding that a deadly weapon was used, namely a motor vehicle, is going to be put a finding made by the court. It won't affect this matter unless your probation is revoked. And if you're found guilty, then if you're revoked and then found guilty and sentenced, you must serve 50%, at least 50% of the sentence before you can be considered for parole, which means if you were sentenced to 20 years on each case, you'd have to serve 10 years, flat time, which is ought to be great inspiration for you to successfully complete probation. Now,
Yes, sir.
these, did you know these people?
Absolutely not. No.
Okay. Well, you can't have any contact with them. Sometimes, a lot of times the defendants and the victims know each other. And unless otherwise ordered, you can't have any contact with these people.
I wanted to contact them after the wreck to see how they were, to make sure they weren't hurt, but I knew I wasn't supposed to.
Yeah, well, you did the right thing because that only gets, it If it's misunderstood, then you're in all kinds of trouble because we take care of victims here. Okay, please see the probation officer and you will begin probation. Thank you.
Thank you.